With Keeney. Kate goes without speaking for most of you, but Kate's been a friend of mine for many years, and also is a principal in her law firm, and has done higher ed law in particular and education law in general for many years. She's given us really good advice on many things, and actually sort of filled in for the general counsel role before I came in between our predecessor.
Yeah, I was going to say she was interim. And she came back today.
I know.
I've been interim twice, Jeff.
Wow.
Yeah,
So
familiar.
Kate is going to cover some of the really important things for all trustees to know. I really do appreciate you being here, Trustee Robinson, and all of you for coming, because I think that these are good things to remind ourselves of, even if you've heard it before, but also if you haven't heard some of these things, particularly in our context before, it'll be a really good introduction to a lot of the principles. So take it away, Kate.
All right, thank you. Just waiting to see So I'm going to cover a lot of material. I think we have 90 minutes total, but we're already a little bit in. Anyone who knows me knows I talk really fast. I can move through a lot of material quickly. So there's a lot of slides in the presentation that you all have as a handout. Some of it I'm going to blow through because it's pretty quick, and some of it we'll spend some more time on. But if anyone has questions, I'm happy to take those at any time. I want this to be helpful and engaging for you all. So, okay, let's see. We got it up here. Just making sure. All right, here we go. Okay, so we're going to talk about the Sunshine Act towards the end.
You're just tiny.
Oh, sorry. Here we go. Thank you. Yeah, I'm trying to make myself taller because I'm stand. So I'd actually need a platform to stand on if there's like,
We can see you for
Okay.
real.
All right, so we're going to go through some governance issues, and this is really, I think, helpful for people who both have been on the board a long time, just as a reminder, and people that are new to the board. And I also think it's helpful. I know we have some new members who've joined the Sales Community College family relatively recently, and I want to just walk through. I think it's helpful to kind of remember, what is a board? Why do we have boards? Like, what is their role? So what I do when I do these presentations is I start by looking at an institution's own policies. And what we're going to talk about today is that there are both statutory ways in which boards are constituted, statutory requirements that boards have to meet, but a lot of the governance that a board provides is through its own policies. So I often start by looking at an institution's policies, or else let's bring those policies into this conversation, because this is the language that you as a board have adopted to talk about what your role is. So I wanted to start first with, this is under your governance policy, and it says the Board of Trustees shall engage in governance that supports the mission, vision, and values of the college. And that's great language and so important. And we talk about the fact that the Board of Trustees exercise appropriate statutory authority and fulfills its responsibilities in a way that is consistent with the mission of the college. And we're going to keep coming back to this idea of mission and appropriate authority, because people are often confused about what a board's role is, and I want to make sure we're really clear on that today. First of all, just as a reminder, for those of you that don't know, you all don't get paid to do this job. You are volunteers. You do this job out of the goodness of your hearts, and you do it as members of the community who have responsibility for public money. And it's a really important role, and I always want to take time to thank every board member for the role they do, the time they give to this important job. But again, you are not paid. You are often not subject matter experts. You don't have to be a subject matter expert to be on a board. And so you have authority given to you through statute, but your job is not to run the college, right? Your job is to provide oversight and to provide some of the things we're going to talk about. So what is the mission that you're here to support? Well, this college's mission that it has defined is empowering students, expanding minds, and changing lives. And that is quite an important mission. And I will tell you all, my husband is a first-generation college student who started out in community college. So I personally have been touched by the work community colleges do, and I am grateful for it. And I know many in our region are as well, for the important work that you do here. You help power our workforce, you give people opportunities, and this is what you do, and we're going to talk about the ways in which you do it. So what are the values that you have defined? Your first value that you list is students first. Everything we do supports student success and removes barriers. Respect for all. We promote equitable treatment and respectful discourse in all interactions with students, each other, and the community. Integrity. We act with honesty, trustworthiness, and ethical behavior. And again, just to put this in context, this is the board's language. This is the policy the board has adopted. So you all always have the opportunity to change this language, tweak this language, but this is how it exists now. You also talk about the value of collaboration, that you work collectively, you achieve more than working individually or within separate groups. And we're gonna come back to that collaboration also again and again, because one of the points of being on a board is none of you individually has any power. It is collectively and through acting as a majority of the board that you're able to make change. And the last value that you all have is data informed. We make decisions in the best interest of students and the institution based on reliable data. All right, so I'm gonna walk through now your policies that talk about how you actually govern. And you all have articulated specific pieces of this. I haven't listed every single one here. I've highlighted some that I think are really important. But the first one that you have in your policy, and this is your numbering, not mine. Your numbering is you're gonna be proactive in supporting the chancellor and the college leadership team. That is so incredibly important because again, you all aren't paid to come here and run the college. You provide oversight and you have identified that your number one goal in governance is to be proactive in supporting the chancellor and the college leadership team. So there's also, it talks about the importance of keeping informed about what's happening. And of course that is important to know what trends are there, what direction the college needs to be going to serving the interest of the area that you are elected to serve. The number 3 on your governance where you talk about what is important is embracing its task with an approach that emphasizes outward vision, respectful consideration of all viewpoints, and then I've highlighted this one, strategic leadership more than administrative detail by exercising overview of administrative functions delegated to the chancellor. The chancellor, and I'm going to come back to this later, you have one employee as the board, and that employee is your chancellor. Right. Let's all say it together. Who is your employee? Chancellor Pittman, that's right. You have one employee, he's right there. And that means that through him, the work of the college happens. And if there's something that you're unhappy about, he is the person, sorry Chancellor Pittman, he is the person who gets to hear about it because he's the person that responds to you. Yep. The rest of the employees of the college come up through other reporting structures, not to the board, but up through Chancellor Pittman. And that is an important delegation because again, you all are employees here. You don't have the same opportunity to review information. It's just not, it's not reasonable or what you're asked to do as part of this job. All right, so going another policy about governance, it says more specifically, the Board of Trustees will, and again, your number 1 is operate always mindful of its civic trustee obligation to the citizens and students of the college district. That is your constituency. Your constituency are the citizenry of the St. Louis Community College District, as well as the students that you serve. And you are always operating in a way that puts them first. And then you've also listed lead and inspire the college through the careful establishment of organizational goals and perspectives through written policies. And I know that you all have invested a lot of time in the last few years to your written policies, wanting them to reflect the goals that you have for the college. And that is important because you want to make sure that you are actually having written policies that allow the work of the administration to be done in a way that is consistent with your vision and mission. And then the third one you identify is focus on the intended long-term impact of the college's goals. You are supposed to have a long view. This is a long-term investment. Education is a long-term investment in the region, and you all have to be always looking at what is the next thing that the region needs? What are the next type of jobs this region needs? And you all have to be visionaries in identifying those things. All right, so then 4, initiate policy formation and be active in strategic and fiscal planning. 5, monitor and regularly discuss the Board of Trustees' own process and performance. Ensure the continuity of its governance capabilities by continual trustee education and annual evaluation. I highlighted that one because you're doing that right here today, right? You are living your written mission, your written values here by having yourselves doing continuing trustee education and taking time to kind of think about and not just take for granted that you already know what's in your policies. The next one is demonstrate commitment and accountability to the general public by competent, conscientious, and effective decision-making. Again, these are all things that I know we all know, but I think it's so helpful to see that you've written them down and that you've identified to the public, this is how we govern. And you also have included that you welcome public input from various sources, including staff, students, alumni, employers, and community members on the formation of the Board of Trustees goals and actions. And I know you all take efforts to solicit all that type of input to figure out what type of thing you're going to be doing next. All right, you also, and I do not see this in all policies, your board has a written board job description in your policies. And that is notable. As I said, I work with a lot of colleges, a lot of community colleges, and not every board has taken the time to actually write out what its job description is. So I wanted to also highlight that for you. One of the things you identify is you say we provide ways and means for obtaining adequate financial support, including but not limited to, and you identify the specific requirements of approving the annual budget, which you all do have to do statutorily, and the expenditure of all funds, and that you also approve an annual staffing plan. So you all have identified these are things that we're going to do every year. We're putting them in our job description. These are things that are important to us. Now, I talked about this earlier, but I want to spend some time on this concept because I think it's a really important concept. By law and by your policies, no board member possesses authority over the college as an individual. This is in your board some of your board policies. And here, the idea is that authority is exercised as a whole. And so I think about this a lot when, as legal counsel to boards, and in Lucy's job for you all, if one of you calls Lucy and says, Lucy, I want to do this, Lucy can't do that because Lucy responds to her job is to do the work of the board. The board is a majority, right? So the board is 4 of you acting together. No single board member has any ability to make any individual decision making. All of it has to be exercised as a whole. So, truly, no board member has any greater rights than any student or any other member of the community. And I always think about this. I had a board many, many years ago where the board member came onto a board. She was a wonderful person, a very caring person. And she reached out to HR and said, please send me the name and birthday of every person in the district. And HR called me and they said, we don't want to say no to a board member, but this woman has asked for this because she was going to send everyone a card on their birthday. I was like, wow, that's really ambitious, but okay. But she does not have the right to that information. And of course, as attorneys, we're like, we really don't want to be giving out everyone's birth date to anyone because that can cause a lot of problems. But she had no authority to ask for that. And I think she forgot because she was a board member and she thought, well, I'm going to do something nice. And the poor HR person had to very nicely say back to them, I know you're doing this for all the right reasons, but we can't give you that information and you're not entitled to ask for that information because we wouldn't, if someone called us up from the public, we wouldn't give them every person's birth date because of course we can't do that. And so when you're thinking about information you have access to, think about if any member of the public were to call and call Dr. Pittman and say, Dr. Pittman, I'd like X, Y, and Z. If any member of the public isn't available, it's not available to them, it's not available to you as an individual. You all decide as a group what information you think the administration should be providing you, and as a group, you give those requests to the administration. So we talked about what that means. I also want to talk to you about your code of conduct. So you all have adopted a code of conduct, which is also, I think, a really important part of many board policies. And your code of conduct actually says Board of Trustee members may not attempt to exercise individual authority over the college except as explicitly set forth in board policy. Board of Trustee members' interactions with the chancellor and with staff must recognize the lack of authority over any individual board member or group of Board of Trustees members except as noted above. And you also say Board of Trustee members will use established lines of college administrative authority and not interfere in the normal procedures for handling complaints or grievances. And I want to take a minute to really focus in on this particular policy, because what I find is the times where this type of policy is violated are usually not times where someone is acting in bad faith. It is most commonly where someone thinks they're helping a neighbor, they're doing something to help a colleague or friend. Sometimes we have board members who used to work at an institution and have a lot of deep relationships with employees there. And many times they think, well, I'm a board member. People expect me to be able to get something done. People expect me to be able to get information. I'm just going to make a call. I'm going to make a call. And a lot of times board members can forget that as a member of the board, they are in a position of authority and power. And it's very nerve-wracking to be an employee at the college and see that a board member is calling you and asking something from you. And not because you try to be intimidating or you're trying to kind of throw your weight around, but just by virtue of your position, you are in positions of authority. And I think it's important to be mindful of that and to remember that you have set your own code of conduct where you have said, we're not going to try to act as individual authorities. We're not going to ignore the established lines of communication. We go through our one employee who is
Our chancellor.
Chancellor Pittman. I'm going to do a lot of call and response today. And a lot of it's going to be Chancellor Pittman is going to be the answer. So I'm just going to give you all that heads up. So that is, and I want to make sure, does anyone have any questions about this particular policy or thoughts about, why or why not this might make sense or any time where this has been something that didn't work for you? Does anyone have any thoughts about this? Everyone's like, no, we don't ever violate this. We know how to do this. Okay, good. Well, and I think it is, the other reason I think it's important to remember this type of policy is that a lot of what your responsibility lies around is fiscal administration, fiscal responsibility. And if you are going to your administrators and asking them to do 20 different things, that takes their focus away from what the group has decided they need to do. And it creates a lot of extra work, a lot of confusion. And I often think of this as a resource management issue. You want to have your chancellor and the administration doing the work you collectively have agreed is the most important work of the college on behalf of your constituents. And if they're getting calls from multiple people or getting asked to do multiple different things, that takes them off course. And they're not able to do the work then that they should be doing to move forward the will of the majority. So I really think this is important, and that's why I'm spending so much time on this slide. And this is something that I think people with very good intentions can unintentionally violate because they think something else might be important. But until the board as a whole thinks it's important, it's not something that should derail what the administration is doing. Yeah, Craig.
Just might add, the practice of the board for some years now has been absolutely in line with this, so no problems. But in the memory of some of us on the board, we had an individual who just completely misunderstood it. Wanted a secretary, wanted an office, didn't understand why there wasn't a salary. So it was really hard to kind of work with that person. And are you going to talk about the fact that we have the ability to remove one board member?
I was not going to talk about that, but I can touch on that.
That's
Yeah.
a very unusual
Yeah.
circumstance for a board. We are the only board I know of like this. And at the same time, it's real. So as members of the board, you should be aware of that particular policy. Not that, again, I started off with what I think is absolutely true. It's not likely that we'll have any need to do anything like that. Hopefully not in the near future. But
yes, you are the only board that has that ability. You are the only community college board with 7 members. So, it is a unique constituency and unique piece of it. I wasn't going to focus today on the removal of board members. I was really thinking more I was going to focus on, board responsibility. But Craig, we can be a downer. Yes, you can be removed. And that is very.
It wasn't a downer at the time. I just want to say that.
It was a necessity. Yeah. No, and it is incredibly uncommon because as elected officials, it is very difficult to be removed, and typically there is not a mechanism to remove elected officials other than we're all living the quo warranto that's been going on in our region. But it is very, very uncommon to remove an elected official from office, and so you have a unique statute that applies only to this community college that does provide a mechanism for removal from board. So don't do anything wrong, guys. Okay.
And it's not terrible. It's a pretty high bar.
It is, and as it should be. This is your rules. You are elected by the public, and you are here because you're here to do the public good. And there are a lot of good arguments that say the public gets to decide, and we should honor the public's wishes in their elected officials, except in very exceptional circumstances. Yeah. So in addition to your own policies, there are also statutes that reinforce this idea about the board needing to act as a whole. So for example, 178A30, which is a statute dealing with community colleges, says a majority of the board constitutes a quorum for the transaction of business, but no contract shall be let, teacher employed or dismissed, or bill approved unless a majority of the whole board votes therefor. And so the distinction that makes there is that there are certain things that the law says you can conduct business if at least 4 of you are at a meeting. But there are some specific things outlined in the statute that you can only do if 4 of you vote to do them. So not only do you have to have, if there are only 4 people there to have a quorum for the meeting, all 4 of you have to agree in order to actually do it. Because in other circumstances, if you had 4 members available, you'd be able to act if 3 people voted, because that would be a majority of the quorum that was present. These specific things require 4 votes to actually do. So it's another way in which the law says you all really need to act as a group. There is also case law that supports this idea, and it talks about the fact that individual board members have no authority to act in their official capacities except during properly called meetings of the board, or unless specifically authorized by a majority of the board at a properly called meeting. And this case is such a weird case. It's an older case, but it's a case where the board members were kind of there was an allegation that board members were going around, and what happened in the case was, it was actually a case about a school district, and there was a board meeting called, and the board voted without any discussion to remove the superintendent and to do some other actions. And so a group of community members sued the board for Sunshine Act violations, saying basically everyone had been acting behind the scenes. Like, how could there not have been some discussion about some of the issues that came up? And the lack of discussion around the issues related in this case caused this litigation that went to trial, went to the Court of Appeals, and ultimately the court did decide that even if, that these folks had, to the extent they had been kind of talking in small groups, they had never constituted a board. And so there wasn't anything to overturn. But I think the larger lesson from this case is that if you act in ways that give the appearance that you're doing things behind the scenes, it can cause you very expensive litigation that can go on for years, and it can undermine the public's trust in the decisions that you make. And so that is why I think it's just a good reminder that for important decisions that the board makes that need to be made in open session, that you want to remember that you need to kind of show your work. We tell kids in school, show your work. And so show the public how you've reached the decision that you've reached, because if you don't, the public might think you're doing something behind the scenes or acting in ways that are not consistent with your obligations under the statute. So this case gives us these rules about, unless authorized by a majority vote, members may not access individual employees, student or other records. We've talked about that somewhat. Order any action to be taken with respect to employees, participate in any meetings, conferences, or other proceedings not otherwise open to the public, or in any way avail themselves of special access or privileges not available to patrons of the district. So I've beat this drum a lot already, which is that as individuals, you have no greater power than what is granted to any member of your constituencies. And I'm beating this drum because we have this drum from case law, so from courts, and we have this drum from statutes, and we have this drum from your own policies. And so it's a really important point, and one that I always like to talk about in these situations as a general governance matter. All right, now I'm going to talk just very briefly about the board's role in some specific matters. And I'm going to go back to some statutes. So there is a statute related to community colleges that says the Board of Trustees shall appoint the employees of the community college, define and assign their powers and duties, and fix their compensation. And you all then also have a policy that talks about some of your statutory responsibilities. And it says approve the appointment, retention, and dismissal of employees, define and assign their powers and duties, and fix their compensation. That might sound familiar because it was on the last slide. It's taken from the statute. And that you approve their contracts. So what does this mean? The role that boards play in personnel matters can often be a source of confusion at different institutions. And I'm curious if any of you on the board want to speak to what your understanding of how this plays out as a board member. And Craig, I'm gonna look to you because you've been on both sides of this, both as an administrator and as a board member, and sort of how you view that meaning within the statute.
So what's your questions, quite specifically?
So given this language about shall appoint the employees, define and assign their powers and duties, and fix their compensation, what is your understanding of the role that the board actually plays with regard to individual personnel matters at the college?
We actually take votes on all kinds of issues around that. So employing people, and we in the last several years have sort of delegated a fair amount of authority to Jeff, Dr. Pittman, but we actually make sure that we honor that law by having a public vote that we employ the people that work for the college.
Yeah, so and I love that you use the word delegate, because that's what's something I was gonna talk about here, which is that a lot of these statutes were passed in like the 1960s when these were much smaller institutions, and there are also, there are 12 community college districts in the state, and there are varying sizes, have varying numbers of employees. You all are a large district, you have a lot of employees. And so the idea that you are gonna sort of fix the job assignment of every single individual member of the community college district is obviously not viable, right? And so what is the way in which we live the spirit of that language that is consistent with what that language says? And it's through the delegation of authority to your one employee who is all right, there we go. So we delegate that authority because, again, getting back to efficiency issues, the board cannot review every job assignment, cannot look at all of these issues. It is just not feasible. It is not a good use of resources or time. And so there are different processes and different mechanisms through which boards do this. I remember when I was a younger lawyer than I am today and starting more early in my career, I read that statute and I was very literal at the time, and I thought, do I have to tell boards they have to actually do this? And I had a conversation with a gentleman who was then the longtime outside counsel for Metropolitan Community College, and he very generously spent some time with me, and we talked about some of these statutes, and I brought this issue up, and he laughed out loud, and he said, you gotta be kidding me if you think that boards have time to vote on every employee about this. And so it is something where the delegation allows you to act within the spirit of the statute and fulfill your statutory duty, but in a way that is actually feasible and allows the business of the college to be done.
So he provides a list, or the HR department provides a list, and we vote on that. So we may employ 150 people at one time, or 10.
A slate, you're given a slate and you approve the slate, yeah.
Good question, only because I'm a new member and not really sure. What if you are contacted, a member is contacted by a student? What is the process? Like if you have a student who wants to air a grievance or something like that, then does the board member then say, hey, I need to connect you with the right?
Yes. And when I would defer to Chancellor Pittman and the members of his administration about exactly how they want you to do that, but the general principle is going to be that there's some consistent way and some consistent person to whom you refer that. You should not be kind of calling and trying to figure out, well, let me get you to this person or that. But figuring out, and it may just be a call to Chancellor Pittman or letting Jessica know, I'm going to tell this person that someone will be reaching out to them. But yeah, you should not need to look through and figure out, well, this is the position or this is that. I think managing the expectation of the individual who reaches out to you and says, you know what, that's not really my role. I don't have specific information. I will let the appropriate people at the college know, and someone will reach out to you. And I don't know, Chancellor Pittman, do you have another opinion about that?
Yeah, that's basically what we do. If a trustee calls me with a student complaint, it depends on the nature of the complaint. Is it an academic complaint, is it a student services complaint? And then I'll get that information to the appropriate person for that. So that work has worked pretty simply. Yeah.
Right. All right, so again, I'm just gonna keep going back. Does the board have any employees? Pittman. All right, yes. So you have a policy about this too. In your board job description, it says the job of the Board of Trustees is to represent the public in determining and requiring appropriate organizational performance. The board will focus its efforts on the following responsibilities within the context of its statutory duties. And the number one thing is select, appoint, and evaluate the chancellor's performance. Because again, you're delegating a lot of that work to your chancellor, who is the one that is fulfilling a lot of those obligations and responsibilities. So one of your most important jobs is the selection of that person, appointing the right person, and evaluating their performance to make sure it's consistent with your expectations and the mission and vision of the college. All right, so I'm going to shift now to the board role and student members. You were omniscient and you knew that was coming next. So we're going to talk a little bit. Yeah, Rodney.
Can you comment just a little bit on the role of the board in terms of the grievance hearing for employees? Sometimes we are in that process, and we actually are a neutral party that stands in to make sure that the employee is heard by a neutral party.
Yeah, so
Talk to that.
You all, and I may have to bring Lucy on this, because I'm a little, because it's been a while since I sat in that seat, I don't have the same memory of all the joint resolutions that I once knew, but you all have a lot of different grievance processes related to different categories of employee. So in your joint resolution, you have general policies where joint resolutions don't apply, and in some of those policies, the board becomes a decision maker at a final stage. And so there is a need for you all to stay out of those issues so that you haven't prejudged or predetermined how your vote's gonna go. And that's important not only for that reason, but also just for appearance reasons, because an employee is not gonna feel like they've gotten a fair shake if they walk in and they think that a decision has already been made without you even having had an opportunity to hear their side of things. And a lot of the work I do, I find a lot of the litigation or a lot of appeals I'm helping with and representing institutions happen because people don't believe they've been treated fairly. Whether they have or they have not, if they don't believe it, there is nothing you're gonna say that's gonna change their mind. And so I'm always very cautious about treating everyone the way you would wanna be treated and being kind and respectful to them regardless of what, whether or not you disagree or think their view doesn't have merit, because if you don't at least give them the chance to say what they wanna say, they're gonna feel like they've never been heard and they're just gonna be mad and not accept your decision. So is that the point you were making, Rodney, is that, because you are the ultimate decision maker in some of those instances, you don't want to prejudge or know much, if anything, about that process until it comes to you in that official capacity. Yeah, Lucy, is there anything you want to add to that based on the?
No, I think that those are all really good points. I do think that historically, I've heard tell that there was a time when there was a lot of soliciting of individual board members by various employee groups or employee individuals. And I think it's really important to remember to always be kind and empathetic, but to not validate, oh my gosh, that's the most horrible thing I've ever heard. Because you're only hearing one person's perspective on a story, and we have lots of processes that are designed to ensure that employees are treated fairly and that the full story comes to light. So, and as Kate has mentioned, that you don't want to give the impression that you have made a decision before it's presented to you in the course of events that are there to protect the employee and to give the employee various avenues of appeal that could resolve their complaint before it ever gets to you. So it's important to make sure that those processes take place.
So similarly, we've talked about processes. The board also has a role in student matters that is defined by statute. So there's actually a statute related to community colleges that has this language that this is a very wordy slide, but I just want to go through it because it actually is a statute. So the governing board of each public community college district shall possess full power and authority to adopt rules and regulations for the guidance and supervision of the conduct of its college students, to enforce compliance therewith, and to delegate to appropriate persons in the district the power to discipline students, including the power of suspension and expulsion for violation of such rules and regulations. So by statute, the statute explicitly says you delegate that there is the authority to discipline students, and you all delegate that, and there can be rules and regulations, and that you can delegate to administration the ability to suspend and expel for violations of those rules. And so you then have also with your role with regard to students in your own policies under the section regarding statutory responsibilities, there are several of these that specifically touch on the board's relationship with students. One of those is that you establish the fees for students in the amount necessary to maintain college courses. You provide instructional programs and services and physical facilities. Obviously, that is all through the administration and all of the employees of the college. You formulate and oversee those disciplinary policies regarding students. That goes back to your statutory authority about actually being able to discipline. And there's language talking about complying with all applicable federal, state, and local mandates. And there are a lot of federal laws and state laws that deal with student rights. Title IX is one that comes to mind quite frequently. So, so you have that within your policies. So before, I'm going to go through one more section. I'm going to just be honest, this is my least favorite section to talk about before we get to the Sunshine Act. There are a lot of rules related to conflict of interest, and the reason we're going to go through these are all things that relate to you in your capacity as elected officials. There are also board policies that mirror the statutory obligations related to being elected officials. The reason why this is my least favorite part to go through is these are the parts that you all really individually have to be responsible for, because it is not the college's job to tell you don't engage in a conflict of interest. You as individual elected officials really have to be aware of your ethical obligations, like through the Missouri Ethics Commission, the rules about running campaigns, and those are things that you need to know. But I do think it's important that it is reflected in college policy, and the conflict issues are things you need to be mindful of as you are in decision-making, as you're in a decision-making role. So conflict of interest laws can be complicated. There are often like very weird relationships that can cause conflicts, but those may involve relationships, special monetary benefits, substantial interest, appearance of favoritism. And so several board policies actually look at these issues and talk about them. I'm going to move through this part relatively quickly just so that I can make sure I get through the Sunshine Act. And there are a lot of slides here, but what I want to just point out to you all is you should not do anything, make any decisions, or vote on anything where you have a financial interest or anyone that is in your closely related to you has a financial interest. If, for example, you have a spouse who has a company that is bidding on work or is considered for a contract, those are things that you should disclose. And a lot of this, and then you should not vote on it, right? You should recuse yourself. A lot of these conflict issues are common sense. And you remember, you are responsible for public money, and you don't want to end up on the front page of the Post-Dispatch. You don't want to end up on KSDK. And so you want to always be thinking about, if this was a headline and I read about another elected official doing this, would I shake my head and say, why did they do that? And so there's a lot of, because it's public money, there is a lot of interest in board members and the decisions they make and what they're doing with that money. And this is what those conflict of interest policies largely deal with. So you have a policy A031, which says no member of the board will directly or indirectly receive any compensation or remuneration, nor derive any profit or gain from membership on the board of trustees or from service rendered to the college. I said it at the beginning, you don't get paid to do this work. And law and policy prohibits you from receiving remuneration for it, because you all signed, you ran for elected office, you agreed to do this work for no remuneration. And so there is also then language in this policy, each member of the board will disclose to the board any personal interest they have in any matter pending before the board. That member will not participate in any discussion or decision on such matters and will abstain from voting. If you have a family member who's up for a position at the college, you should disclose that. You should not vote on it. If you have, again, anything where it could give the appearance that you have a personal interest in it, you should disclose it and not vote on it. And then it also talks about no board of trustees member will use any of the college's equipment, supplies, or personnel for any purpose other than the college's business. So think about it this way. Think about if you're planning, let's say you're on another board and you're planning a meeting somewhere and you think, oh, the college has this nice conference room, I will just pop over there and have my meeting there. If a member of the public wouldn't have access in the same way, you have to follow the same process that the member of the public would do. You don't get any special or preferential treatment because you're on the board. And that's, that's something to remember. I've worked with boards before where, there was like an old truck and somebody, some employee thought they were being nice and they were like, oh, board member, do you want to? And I'm like, no, what are you doing? No, don't do that. So, because there can't ever be the appearance that you are using your position to get some kind of favorable treatment. They're going to go there. You all have a code of conduct that I've referred to a few times. Part of that code of conduct says, it expects ethical, and the board expects ethical and professional conduct from all of you. That you must represent impartial loyalty in fulfilling your responsibilities. It talks about that you have certain reporting obligations that are in addition to and even beyond what's required by law. And so I have all of these slides in here for you all to read. There's this very tiny print, but the board policy is referenced, and I know you can get that in larger print. But I think this is something to just look through. I don't want to harp on this too much. I've put this chart in here. This is actually a chart created by the Missouri School Boards Association, but it's so well done that even though it has a few references to laws that don't necessarily apply to community colleges, I think it's a helpful representation to sort of see what does nepotism mean and how do these charts. And so talking about who you should not employ or appoint where there could create a conflict. So if look through that, and just if any of you ever have a question about a relationship and whether or not it falls within nepotism rules, that's a resource to look at. So I'm going to talk through a quick hypothetical with you, and we'll go through a few of these, and then we'll move into the Sunshine Act portion. So the college has determined that it will need to purchase or build a new building to accommodate an alternative education program. You happen to own a building that your grandfather left you in his will. You offer to sell this to the college at fair market value at a regularly scheduled board meeting. At the next meeting, the board moves and votes to purchase the building from you for fair market value. The board has not given notice of the transaction. Does this create a conflict of interest? Yeah. Yeah, so there are specific statutes talking about the sale of real property. And so, and there are specific laws about this where if the transaction exceeds the amounts, which is $5,000 per year, should not exceed $500 per transaction or $5,000 per year. If it is above that amount, which obviously the sale of land would be, the board has to give public notice of the transaction prior to the contract, and that's to allow others to be aware and maybe come in and there be other offers related to that transaction. And the board member, of course, has to abstain from that vote and should leave the room and not be part of the discussion, because again, you don't want to give the appearance that you're influencing the decision of the board. And it is also important then that board members are filing their personal financial disclosure statements as required by the ethics laws in Missouri. Okay, so you all know about your financial disclosure requirements. I'm going to just move through this part quickly, just as a reminder of that requirement. This is a list of some other types of conflict issues. Again, I think all of you know that you cannot be paid to vote a certain way. Hopefully that's something that's pretty obvious. Or not voting because you were paid a certain way, or that you are using information that you learned by virtue of your membership on the board to benefit you or a family member or your business. Again, I feel like these things are pretty obvious, but there are in statutes, so I wanted to go through that. Yes, Chancellor Pittman.
Kind of a rule of thumb that at least I try to follow, I explain to my staff that, because several of us serve on other boards, like I'm on BJC or United Way, and sometimes they'll, for example, BJC has one of those nice rooms at Bush where you can go in. And I think it's okay for me to do something like that because I'm acting as an agent of BJC. But if Kwame, for example, who's now the construction management firm at Wildwood, says, hey, free car tickets, I say no. I mean, you see that, because when you get down to making decisions about who a CM is going to be, that can really reflect on in a bad way. It can reflect on the employees too. So that's, I mean, even something as small as that, I think could be.
Well, and it creates a headline, right? And it creates a distraction that then undermines your credibility with the public and undermines your ability to be effective in your role. And I'm often just sort of in the mindset of, it's not worth it, right? It's not worth it for the free baseball tickets to like cause something that is going to have people feeling as though you're acting in a way. It's not worth it when a vendor then says, challenges a bid award decision because they say, well, I saw you in the blah, blah box, and so you didn't take my bid seriously. And it's just not worth it. And so those are small things, the small decisions you can make that are going to make it easier to do your job as a board member because there's just going to be less noise around the decisions that you make.
Yeah, when we raise money, I tell the staff vendors are to do not approach Lucy and ask for money. Don't do it. Because back to, at some point, you're going to vote on something involving Lucy.
Lucy, did you want to ask?
Yeah, I think something to keep in mind, I think Kate referenced this earlier when we were talking about another related subject, but many conflict of interest policies and some state statutes prohibit conflicts that create an impropriety or appearance of impropriety. And I had somebody speaking to me, not here, at another institution one time for an hour and a half trying to convince me that something that they wanted to do was not a conflict of interest. And finally I said, I disagree with you, I think it is, but even if it isn't, if it's taken you an hour and a half to convince me, others try to convince me, it creates an appearance of impropriety. So try to think of these things in that light too. If it's going to shed bad light on you personally, on your character, or on the college, more importantly, not that your character's not important, but those are the things to keep in mind when if you have come to a situation where you're just not quite sure.
Yeah, no, that's a great rule of thumb, is like if it's going to take you a while to explain why it's okay, just don't do it. Let's not go there. Great.
I just have a question. In the last several years, the state legislature has cleaned up its act around a lot of this. I mean, they were almost a paper plate. Has that had any impact on other entities, other elected officials? Do we have a different standard, or were they just literally ignoring that standard? Now they aren't, because they have very specific laws that are, aimed at them, but nothing's really changed for the rest of us.
I mean, we haven't seen new statutory requirements come out of that. I think a lot of what's happened in, like, over the last, I don't know, you could say, 5 to 10 years, is there were a lot of norms people accepted as okay, that then suddenly people were like, maybe it's not great that, like, vendors are going into the state capitol and, like, bringing cakes and, like, having parties, like, in our state capitol. Maybe that's not great, I don't know. And suddenly people thought, then that brings more scrutiny. And I was like, I'm from Jefferson City. My dad worked as the general counsel for a lobbyist for a special interest group for his entire career. So I grew up in the shadow of the state capitol. So I grew up with those stories. And I was like, yeah, that's what they do, right? Like, that's just how we roll in Jeff City. But it was, thankfully, people started paying more attention and challenging those norms and trying to clean things up. And I think a lot of that came out of, there were a lot of sexual harassment claims that came out of those parties, and a lot of other issues that were happening that caused people to think maybe we shouldn't do this anymore, and they cleaned that up. But we haven't seen that trickle down to this level. But I think it is just an example of, as a society, we have higher expectations for our elected officials, that we haven't always held them to those standards, and now there's been kind of a reckoning around that and more scrutiny paid. I do think in St. Louis we have, the media really likes to find situations where public officials have done something that looks bad. And one of my favorite board members at another institution, who you probably know, Dr. Larson, famously was being interviewed and got up and said, I know you're gonna try to take a picture of my back as I walk out, so I'm gonna back out of the room facing the camera. And he was on camera doing this. And I was like, I love you, Lynn Beckwith. So you probably know Dr. Beckwith. And it was amazing. But the media loves to find places where it looks like public officials are doing something wrong, and then put you on the front page, or put you on.
You paid for it.
Yeah, you paid for it. That's exactly what it was. That's exactly. And he said, you will not take a picture of me walking away from you. So he walked out backwards. So it was amazing. So the consequences for violating those conflict laws are actually, they're actually violation of laws. So exceeding to corruption is a Class D felony. The offense of official misconduct is a Class A misdemeanor. Misuse of official information is a Class A misdemeanor. So, and in some cases, your failure to file financial statements can result in removal from office. So there are real, in addition to it looks bad, it makes your job harder as a board member, there can be legal consequences to violating these conflict rules as well. All right, with that, I'm gonna shift gears into the Sunshine Law. Before I do that, does anyone have any other thoughts or questions about governance issues? Lucy, is there anything else you wanna add that we didn't cover?
Thank you.
Okay, so I'm going to shift gear now. We're going to talk about the Sunshine Law. All right, so the Open Meetings Act, it was introduced, and speaking of responses to government corruption, it was introduced in 1973, 7 years after the federal Freedom of Information Act was passed in Congress. We'll just say I'm a history person, so I always love knowing what years laws were passed, because here we're like, oh, this follows Watergate. So at that point, there was a lot of interest in government transparency. And so, states around the country are enacting laws. And so Missouri is part of a wave of folks who, after Watergate, are thinking, you know what, maybe we should know what government is doing. And they enact our Sunshine Act. And so the purpose of it is to encourage openness in government. And it is meant to give the public access to how the public's money is being spent and the decision-making process that elected officials are engaging in. So what the law does is it mandates open meetings, open records, and open votes unless they are expressly closed by the Sunshine Law or some other law. And the law actually says on its face that if a court is asked to interpret issues around the Sunshine Act, they should interpret it in a way that promotes the openness of it. So the default is that it's going to be an open record unless the statute explicitly said it's a closed record. Now, there are gray areas around some of these pieces, but it's helpful to know that if there is a question, the court is going to default to openness as opposed to allowing something to be closed. So I'm going to go through the definitions in the statute, and I'm going to just kind of level set here and say, as we talk about this, a lot of people find the Sunshine Act frustrating because, you know, well, we feel like, well, we have all these, I'll just tell you, our Sunshine Law Act is much easier to comply with than our neighbors across the river in Illinois. In Illinois, personnel records are open records. In Illinois, all board meetings have to be recorded and provided to people that want them. I mean, so as we're talking about this, just remember, this isn't as bad as it could be in other states. So if it seems like a lot, it's actually not as much as many states have. So the definitions here that are important are first thinking about governmental bodies, because these are the bodies to whom the Sunshine Act is going to apply. So a governmental body does not just include the board. It actually includes both the board and committees appointed by or at the direction of the board, which are authorized to report to the board. And a lot of people don't know about that, but there is actually a requirement that those committees also be considered governmental bodies that comply. Another key definition is public records. So any record, whether written or electronically stored, retained by or of any public governmental body, including any report, survey, memorandum, or other document or study prepared for the public governmental body by a consultant or other professional service paid for, in part by, this is a long definition. But and this is one of the places where there are often a lot of fights about what constitutes a public record. But for board members, when you get a packet, that is a public record. It is a public, and it may be closed, but it's a public record, because there's not really any question about this. So the question becomes at lower levels within institutions and within governmental bodies, like how deep do you go and say something is a record? But there is no question that the documentation that you all have access to, because you are a decision-making body, is going to be considered a public record. Your board packets, whatever information you get. A public meeting is defined as any meeting of a public governmental body at which public business is discussed, decided, or public policy formulated. So how many board members have to participate in order for a meeting to become a public meeting? Ready? 4, yeah. So so if 4 of you get together and you're talking about policy, that's a meeting under the law. And I will tell you all, one of my like young lawyer moments was I went to a board meeting for a school district because I was doing a student discipline hearing. And afterwards, the board said, hey, we get together, we all go to McDonald's after the board meeting and get some dinner. Do you want to go with us? And I was like, sure. So I get there and they all sit down and they immediately start talking about all of the board's business. Oh, no. And I just got up and said, I gotta go. I can't hear this. But it's something that you really have to be mindful of. And again, I talked earlier about the Colombo lawsuit, where there were, taxpayers brought a lawsuit because they had the perception that the board was talking about all of this stuff outside of the meetings and making decisions. Those meetings that they were having at McDonald's were probably public meetings. I mean, they were all there, they were all talking about it. Now, they weren't voting, but they were formulating, they were talking, and someone could have said, this is a public meeting. And so there are exceptions where, the law does say if you're getting together for social reasons, that's not a public meeting. You all can obviously go, there can be like things that you all can be at that aren't public meetings. But if you are talking and discussing and deciding public policy, and there are 4 of you, that's going to be a public meeting under the law. So the thing with open meetings and votes, citizens have the right to attend and observe open meetings. Citizens have the right under the law to videotape such meetings, although the board can establish guidelines to minimize disruption. I think now this isn't that, it's not that big a deal to think about videotaping, because we all could be videotaped at any time with people's phones. But I've been, years ago, I remember being at a board meeting where it was very controversial, and a member of the public just stood there with a video camera to try to intimidate the board members, and just took everyone's video, and we actually had to put a policy in place about minimizing disruption, because they were doing it to try to intimidate. They would focus in and they would stand up and stand in other people's ways. But they do have the right to videotape, so we have to be mindful of that. Under the open meetings law, the board is required to give notice of the time, date, and place of each meeting and a tentative agenda in a manner that's reasonably calculated to advise the public. And that is so the public knows what you're going to be talking about and can decide whether they want to participate in the meeting. The notice has to be posted prominently in the principal office of the college. The notice must be posted at least 24 hours before the meeting, unless such notice is impossible or impractical. I'm gonna tell you all, it is almost never impossible to post notice at least 24 hours out. I sometimes get requests saying, hey, can we, like, you know, not do that? I'm like, well, what's the reason gonna be? Because if there wasn't a tornado that came through and like changed everything, it's gonna be hard for us to say we couldn't do it in 24 hours. So can boards meet via electronic means like internet chat or message boards, telephone? What do we think? Yes. Yep. So COVID has taught us a lot about the Sunshine Act. So the notice has to identify the mode by which the meeting will be conducted, and it has to be done in a way that allows the public access. And it's, you know, as we talk about this in 2023, we're all so accustomed to Zoom that it seems like silly to even have this conversation. But, you know, in earlier days, there were discussion about, well, can boards meet by internet chat? And we had to talk about, well, how will the public get access to that? Because we always have to allow the public to be able to listen. Now, there are limitations on voting if you're not physically present or video conferencing. And there is an actual requirement that to vote, and we're going to talk about this more when we get to the closed meetings, but to participate in a roll call vote, you have to be physically present or participating by video conference, which for most of us now means Zoom. Okay, so we're just going to walk through a sort of hypothetical that's going to touch on pieces of this to just make some of the points. So the board would like to sell a parcel of land that is no longer useful. The board wants to discuss the possibility of selling the real estate. Should that discussion happen in open or closed session? They're talking about selling land owned by the college. What do y'all think? Closed, yep. So there is one of the reasons you can close are related to discussions regarding leasing, purchase, or sale of real estate. Each of the reasons for having closed sessions are specifically articulated in the statute. They're all in 610-021. And if you look at it, there's a reason why each of them are allowed to be closed. So if you think about, well, why would the board be able to talk about that in closed session? Well, they're engaging in some type of transaction on behalf of the college where they should be bringing in as much money for the college as possible. It would make sense then that they can talk about that, but not in the public where everyone could hear what they are thinking about selling for. So that can be in closed. So a closed meeting, a closed record, or closed vote is defined as any meeting, record, or vote closed to the public. So you actually have to follow certain protocols in order to have closed meetings. So first you have to have the notice and the reason for closing the meeting, you have to post it. And that reason has to be one of the articulated reasons in the statute. It can't just be because we feel like it. You know, there are specific articulated reasons for closing meetings, and you have to list the one that applies. The board members must authorize to hold the closed meeting by a majority vote that is taken in an open meeting. I know, Craig, we talked about this once years ago because you all do yours a little differently than other boards do. I think you vote at the prior meeting, so then, right. So you all vote at your meeting that you're gonna have a closed session in the future, but that vote is taken.
How is that different? I don't remember.
A lot of people vote at the actual meeting itself, and so they'll go into their open session and then they'll vote to go into closed session at this contemporaneous with the meeting itself.
You do hold a vote to go into closed session.
Oh, you approve the agenda at the prior meeting? Yeah, okay. So then the vote to go into closed must be taken in the open meeting so the public is aware of it. And the motion should include the reason for closing the meeting. So again, the reason has to be both in the notice and in the actual vote itself. And so that's why you'll hear, probably hear something like, can I get a motion to go into closed session, move to go into closed session for reasons authorized under statute, including 610-021 subsection blah, 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 blah. And that is there because you have to let the public know what are the topics that are allowed to go into closed session for. And that vote to go into closed session has to be done by roll call, which is the kind of call and response. So the notice of those meetings, yeah.
Small question.
Yeah.
We actually are doing a fair amount of bringing board members into meetings by video, right? And FaceTime, I'm wondering, is that all right? If
It's a video conference,
as
yeah.
long as somebody's visible to another
Yes.
member of the board, because FaceTime, they're probably not on a camera like that, they're just looking
Yeah,
at it.
the idea is that you're sort of able to verify that you can see them, you can physically see them. So I certainly would try to do it in a way that everyone is able to observe them to the extent possible.
So if we can, we conference people in here. Jessica's really good about doing that, or actually.
They're like job security over here.
Yeah, our technology staff's really good about doing that. But I just want the board members to know that if something happens and you're not able to do what you thought you were gonna do, is be here, and you could come in by some appropriate means. And that can just be a phone, so, you know, that you don't have FaceTime, you're just gonna listen, that's fine, you can listen, you just can't vote on
Can't vote in closed session.
closed session items.
Or
Can you
anything that's
vote
a roll
on
call.
regular?
Well, anything that's a roll call vote, you can't do.
But if it's
It's-
all in favor,
Technically, but I actually would probably encourage you not to do that, because those ayes that are just like aye, it becomes sort of hard to record if it's just like, you know, you're probably doing most of your votes by roll call and they can't participate if it's a roll call vote. So, you know, it's safer to assume that if you're not there by
but
video
again,
conference.
FaceTime, which most of
Yeah.
us have iPhones, or
Yeah.
you actually have an
You mean, you
iPad.
see their face and they cannot vote?
No, if you can
Yes,
see their
yeah.
face, you can
Oh,
vote.
okay, 'cause
Yeah.
If you're just listening on the phone,
You
which
cannot,
sometimes
yeah.
we do,
Okay.
you know, it's too awkward to be visible.
I got it now, and you all just kept talking, and
Sorry.
it's like you were reversing what you were saying.
I just think that's one of the things that we actually do a lot of, and
We
we
do.
need to make sure we understand that. Because it's good to have a member who, you know, not feeling well and you're gonna stay home, but better that you listen to the conversation.
Yeah, you just have to know that your participation is gonna be limited if you're not participating through video conference, right, as opposed to, you know, other things. So this issue around closed meetings, one of the technical issues relate to the fact that you have to, you know, cite to a specific reason that has to be in the notice, in the agenda, in the vote about why you're going to close, and then it also needs to be included in the minutes. So you go into closed session, your minutes need to reflect that reason for going into closed session. So when is it appropriate to call an emergency closed session of the board? If you really can't do it in less than 24 hours notice. And that again is a very, very rare circumstance. I mean, the best example I can think of is, I remember seeing a presentation done by the attorney that represented Joplin, and after the tornadoes went through Joplin, they had a good reason to call an emergency board meeting. And that is a dramatic example, but it really does, that is a situation. There aren't a lot of situations where you're not gonna be able to do 24 hours notice, because the standard is, was it impossible or impractical to give the notice? And in this day and age, you know, it's pretty easy to give 24 hours notice. So I mentioned before that the statute lists out specific reasons why you can go into closed session. These are the ones that we see the most often. They're not the only reasons. Of course, my personal favorite is legal action, because as a lawyer, if I'm coming to give advice somewhere that's privileged and confidential, that can be a reason to go into closed session. We already talked about the real estate issue. Issues around personnel where there is hiring, firing, discipline, or promotion of particular employees. So where you're going to be talking about individualized personnel information, that can be done in closed session. But issues where you're just approving a slate and you're not going to be talking about individualized personnel records would generally be appropriate for open session. Matters about students are going to be part of closed session, in part because FERPA creates privacy rights for students, and our Sunshine Act says information otherwise protected by law. And so because FERPA protects student information, that's going to be a basis to close records. Preparation and discussions related to negotiation with employee groups are a reason why you can go into closed session. And then again, we talked about those individually identified personnel records. So the thing that I always, you know, we remind folks, and this is where people sometimes get annoyed with the lawyer in the room, so hopefully Lucy hasn't had to do this, but once you're in closed session, it is not a free-for-all. It's not like, okay, we're here, so what do we want to talk about? You can only talk about the things that were actually on your notice and the things that were in the vote that you took. So just because you've gone into the closed meeting appropriately does not mean that you can do whatever you want once you're in there. Again, you can only talk about what was on your notice and what was in your vote and those specific topics. And so you sometimes are going to need to, if something comes up later, you know, like after the agenda's been published, you may need to amend your notice and agenda prior to 24 hours in advance of your meeting, but you're going to have each of those reasons articulated before you're allowed to talk about those topics. All right.
Lucy would tell you that that's a harder thing to enforce than you might imagine.
No, I know it's hard. That's why I already called.
It's hard, but not because it's intentional. I think that
People just get enthusiastic,
things that
yeah.
usually flow into something else, and it's hard to keep it.
And I think it's important, like, and I will just say, I mean, I've been in many meetings where that, and sometimes I'm like, is it worth it to kind of throw myself on the table and tell them to stop talking, or am I just gonna let it go? But in the place where I typically draw the line is if someone tries to vote on something, because the vote can be reversed. I mean, it is a basis to reverse the vote you've taken if you have not properly noticed it up. And again, just being mindful of, if it wasn't on the notice, then anyone can challenge what happened in the meeting, and that record is potentially not closed and can be something that people can get access to. So, yes.
Oh, I was just gonna say, I guess I've been lucky in the many closed sessions I've been in with, AFT, Teachers Union and on board member and all like that. There's always somebody in the room that will remind you, that's not what we're supposed to be talking about. And it stops immediately.
That's good. That's good. Got compliant. You've been on compliant boards then. That's very good. So this is just a list of sort of, again, sort of the general reasons for closed meetings, and just makes the point that if it is not on the list of things that can be closed, it is open and cannot be discussed in closed session. So this is, we like to talk about the Vegas rule for boards. So what happens in closed session, stays in closed session, and those records are closed, and there are actually penalties for violating it. And one of the other issues to think about is that by being on the board, if one of the things you're talking about in closed session is attorney-client communications, that information is privileged. And if you talk about it outside of the session, you are then putting the board in a position where someone could potentially argue that that privilege has been waived. And I know for Lucy and me, we're very concerned about making sure that privilege attaches where it is supposed to attach, because we want to be able to give good advice and have robust discussions. And that's true for anything in closed session. The point of closed session is to allow the board to talk about things that can be hard topics and trust that they can have a robust discussion, and that someone is not going to go out and then talk about it. I can tell you one of the most dysfunctional issues that we see on boards in our office is when there is a lack of trust about keeping things confidential, and people breach the trust and they talk about things outside of closed session, because what happens there is that boards become unable to function, because they can't have real conversations and meaningful conversations in closed session, and they basically stop making decisions. And it's very toxic, and I'm so grateful. I know your board is not in that situation. But
It has been.
They have been. I mean, I wasn't gonna say it, but.
We thank God for now.
But yeah, you don't have that now, but it
It's
is.
been some years, but
Yeah. And it is toxic, and it means it also.
it really puts the chancellor in a very awkward position, trying to figure out how to move forward. You want to get guidance, you want to talk about things, but, the whole idea is we're talking about it, we're not voting on it, so we don't want everybody else to know about it, especially the people that might be impacted by it.
Yeah, no, it's really difficult. And so knowing when you can talk about issues in closed session, and then sticking to those issues, and then having robust discussions where everyone knows they need to honor confidentiality, is so important for a well-functioning board. That trust is just incredibly important. And you actually have this in your board member code of conduct, in your policy A07. There's language that says Board of Trustee members may not waive Board of Trustees' rights to confidentiality, including discussions that occur at legally held closed meetings of the Board of Trustees, and other privileged communications such as attorney-client privileged communications. I will say I oftentimes see language in policies that is a reflection of something that has happened that people don't want to have happen again. I'm not saying that happened here, but it is in your own code of conduct that you will not waive confidentiality in closed sessions. All right, so we've already talked about this. I'll just hit on this very briefly again, that when you have.
Let me just tag, you, a while ago, you said, one of the hard things as board members is we get a phone call. And that phone call can be from, often in our college, from an employee, but it could be from a student, it could be from a citizen that has some interest. And knowing how to handle that. And it ties into this whole confidentiality in many situations. They're trying to get you to be aware of something that you may not be aware of for a lot of good reasons. And once you know that, you can't unknow it, right? So it's a mess.
Yeah. No, and some other issues that come up around when you have, so we kind of use the term leaky board members in our office, but is that not only does it damage the decision-making around all of you and your relationship with each other, your relationship with your chancellor who needs direction from you, but you just hit on, it can make administrators, employees, or others fearful of discussing issues, like in letting the board know because they don't trust that it's gonna stay where it needs to stay, can damage the legal strategy. I mean, we've had issues where we've had boards that are, districts that have been subject to litigation, and there's a split board where some of the board members are friends with the plaintiff in the case. And so being able to figure out, can we settle? What should we do? We're not able to have those conversations with the boards, which means we can't move forward and can't figure out what to do in litigation. And so it's very difficult business decisions about buying property or entering into things. If you don't trust that you can have a robust discussion, it can be really damaging. And it really can, develop into a public distrust issue where the public views the board as not functioning, and it's not functioning when it can't have robust discussions. And so all of those things are reasons why confidentiality is so important. Now we go back to this hypothetical
I
about.
have one more
Yeah, please,
insert.
please.
What you just said is so on track. You're not functioning, and there are members of the public who are happy with that situation. That's what they're trying to accomplish, is stop the board from being able to function. And fortunately, we've been pretty united and made some tough decisions over the last 4 or 5 years. But
Amen.
No, on that note, I was giving a similar training to another board at another institution, and I got to that slide, and the board member looked at me and said, one of the board members looked at me and said, will you assume that we all want the board to make decisions? And I said, yes, I do assume that, since you are on the board and that's what you were elected to do. So I'm just glad it's members, but it's very toxic when you have a board member who does not actually want to accomplish anything and uses that as a basis to kind of create wedges on the board. So I'm thankful you all do not have that situation. So getting back.
we're thankful too.
Yes, it's very painful to have that situation, as many of you know. So the board, let's go back to our hypothetical. The board has chosen a real estate agent and decides that the chair of the board is the member that will email or telephone the agent to discuss the sale. Are the chair's emails to the real estate agent open or closed records? That's right. Whoops, closed, yeah. What about the emails the chair sends to the rest of the board following discussions with the agent? Closed, yeah. So let's talk for a little bit about email. There are we actually have some specific rules about email that are in the statute. And email, now we've sort of gotten used to it, but it's like the bane of lawyers' existence. Emails and text messages and all the things.
Teams chat.
Teams, yes, Teams, Slack, all of it. Oh my gosh. So any board member there's actually a specific rule about how you have to handle email. So any board member who sends an electronic message about public business must copy custodian of records when the message is sent to 3 or more board members. Why would that be? Why does that number matter? Rodney, I know you know the answer to this. 4. That's right, that's what I was looking for, that 4. Once you've got 4, you've got a meeting. That email becomes a meeting because there are 4 of you on the email. And so what that means is, I believe Jessica is your custodian of records, so that means Jessica has to be copied if 4 of you are on an email together. Okay. Because that email has to be retained by your custodian in order, to comply with public records law. I'm gonna make a plug here that I hope isn't necessary because I hope you're all already doing it. Please, please, please use your St. Louis Community College email addresses, because it makes Jessica's job so much easier. And the other issue is, whenever Jessica or others are responding to email requests, just because you sent it from your private email account does not mean it is not subject to the Sunshine Act. If you are conducting public business on your private email account, those emails are still subject to Sunshine Act requests. And it makes Jessica's job very difficult when she has to call you and say, I need to search your private email account. I need you to give me these emails. Save everyone the headache and use your STLCC email account. It will make your life easier, it will make Jessica's life easier, and it will make Lucy's life easier. So again, that message is a public record subject to exceptions for closed records. So there also are some Attorney General guidelines around email because, as you might imagine, this issue comes up with great frequency. And they've provided guidance saying a single email about an issue would not itself constitute a meeting require advance notice. I'm just going to take a minute to say that the Attorney General has given thought to whether you sending emails to each other requires you to give the public notice that you are sending emails to each other, because there are 4 of you and that is a meeting. Just think about that for a minute. There's an AG opinion about this. So again, this is just think about your email use. So they say, however, under 610.025, any member of a public governmental body who sends an email relating to public business to a majority of the body has to copy the custodian of records. So again, we have a statute that says that, we have an AG opinion that says that, emails are a big deal, as are now Teams messages and everything else. All right, so the board has chosen a real estate agent that the board decides, let's see, we've already talked about this, they're closed because they're related to the real estate matters, and again, they remain closed even as they are shared with other members of the board. Okay, so does anything change? I just sort of previewed, you all should know the answer to this. Does anything change here if the chair is emailing the real estate agent from her personal email account?
No.
No, the chair must still retain that email because it relates to public business. And again, must still concurrently copy the custodian of records. Again, don't use your private email accounts. It just makes everything harder. Okay, again, here I have it, easier to transact on a college email. Okay, what about other forms of communication, text messages, communications, and other types of apps? Does the form of the communication matter? No, which is terrible, but it's true. Oh, it's such a pain. But yeah, you think about how do you communicate, and you might even give thought to, like, how do we want to communicate as a board? Do we want to say to each other, maybe we shouldn't text? Like, let's not, let's think about how we want to do this. I hope there are no chain texts on any of your phones that have 4 of you on them, because again, that is a meeting, and you're going to have Jessica on that text chain. Jessica does not want those text messages, friends. She does not want them. So yeah, it does not matter the form. If you're having those communication, they are open records. All right, back to our hypothetical. The board receives a great offer, but the board would like to discuss the offer and possible negotiations. Does that discussion happen in open or closed session? Closed, that's right. There are records that morph. So there are records that originally start as closed and then become open. And so the ones that become open are any vote on the final decision to hire, fire, discipline, or promote an employee must be made available within 72 hours after the meeting and must include how each member voted. Does anyone know why we have that 72-hour window? That 72-hour window is there so that you can notify the employee of the outcome of the vote before the public finds out. I have a board where they had just gotten board docs and were figuring out how to use it. The board voted on a termination. This board secretary uploaded it to board docs and made it open inadvertently, and the employee found out they had been fired on board docs. So that 72-hour window is meant, which was not great, just saying this, I don't recommend. But that 72-hour window it's not a requirement, but it is meant to give you time to notify the employee so they don't find out through board docs that they have been terminated. And those records don't automatically have to make them public, but if there is a request for them after 72 hours, you have to provide them, even though the vote was initially done in closed session.
That's such an important.
Yes.
I struggle with understanding that. So, if you're doing something that's relatively important, which could be to an employee or it could be like you've been talking real estate, and no one asked for the information, we don't have to.
Or you don't have to vote. So just
We don't have to develop closed door minutes that are redacted, but provide that information and must give that out in 72 hours.
No, you don't. There's no push out requirement. If it is requested, it becomes a record that is subject to request because it is open. And at that point, you do have to redact the closed portions out and provide the portions that morph to the requester. Yeah.
I've struggled with that over the years, just to understand it around specific issues.
It's just, it's really not that many. It's the issue of that vote, that decision about, the final decision about hiring, firing, disciplining, or promoting an employee is one. The other one is a minute vote or public record approving a contract to lease, sell, or purchase real estate becomes public upon execution of the document. So once there is a sign off on that contract to sign, to sell that land, that execution makes it convert to a public record.
But again, just because it's now a public record doesn't mean we have to push it out.
Right, that's right.
It's just if the competitor bid, ask us what you do, then we have to tell them.
Right, yep. And so we've just got a reminder here that the custodian of records should not disclose closed minutes to the public without first reviewing for items that are closed to the public. So I have this situation now where I have a college who is in a contractual dispute, And another thing that is not explicit in the statute, but is true just through case law and other things, is that any contracts that the college enters into are public records. So like employment contracts, all of those are public records. And contracts you enter into with vendors, all of those are public records. You know, those contracts are public documents. So we have a vendor who is asking for all of the records of discussions about entering into this series of contracts. And so we're having to go through and provide them all the public records for this like 2-year period, and then we're having to go through the closement and just making sure that there isn't anything in there related to this that we then have to redact out. Now there shouldn't be, because none of this should have happened in closed session, but you never know, so you gotta be careful. Okay, so the board receives a great offer, but the board would like to discuss the offer and the possible negotiations. We've already talked about that it is closed because it relates to a negotiated real estate contract. Now, the board has negotiated an even better offer of sale, and it feels ready to vote on accepting or rejecting the contract. Can the vote happen in closed session, or does it need to be an open session? This is a vote to actually accept the contract. Closed, yeah. So, and that's because, again, that we talked about earlier, that the board has the ability to try to get the best deal. It can vote on the record vote on the contract and close, but this is one of those records that morphs. And so once they approve it, it becomes a public upon execution of the sale. Okay, so what is a public vote? Any vote cast at a public meeting, whether conducted in person, by telephone, or any other electronic means. All votes must be recorded in the minutes. That is Jessica's great job. All votes authorizing going into closed session must be made by roll call. All votes cast in closed session must be made by roll call. So you can do roll call votes in open session if you wish, but anything in closed session has to be by roll call. Here we talk.
Can a board member ask to do a roll
Yes.
call vote?
Yes.
In open session?
Yes, yes,
And that would be to record the vote?
yep,
And any one board member can ask that?
Yep.
And it asks that?
yep. Any board member can request that a vote in open session be done by roll call vote. So, and we've talked about a lot of this, and I know we're running short on time, so I'll move through this quickly, but we've talked about that only members who are physically present or participate by video conference, which could be FaceTime, may participate in a roll call vote. So that's any vote in closed session and any roll call vote in public session, open session. If there is an emergency closed meeting, which again is not going to happen very often, because most of the time we're going to have more than 24 hours to know that we need a meeting, the board members may vote electronically if a quorum is physically present. This is a really antiquated rule, but anyway, it's there. Okay, so who can sue if they allege a violation of the Sunshine Act? Any taxpayer, any citizen of the state has standing. Local prosecutors can sue, as can the Attorney General. Remedies for violations of the Sunshine Act. Courts can actually void decisions made by the board if they were not made appropriately within the appropriate closed or open session. I litigated a case once where a board was voting on a reduction in force, and the union sued saying you did not properly notice the meeting where you voted on the reduction in force, and so we think the court should reverse the decision you made. We called another meeting, properly noticed it, and had them re-vote, but we still had to deal with the litigation. And so you have to really be thoughtful about that. The court can also order the board or individual members to pay a fine. That fine comes out of your pockets. That is not something the college would indemnify you for. If there is an allegation that a board member violates, it's $1,000 for a knowing violation, a $5,000 fee for a purposeful violation. The board can order the board or individual members to pay the reasonable attorney's fees and the cost of the plaintiff for having to bring the case to enforce the Sunshine Act. So if you're demonstrating compliance with the Sunshine Act, you want to make sure you have a written policy, which you all do. You want to make sure you're maintaining those notices with a record of all of the dates. You want to make sure that you are meeting and providing that notice with more than 24 hours notice. And the meeting should include those votes in the way we've talked about. So roll call votes for every vote taken and closed, votes showing the open votes, and a board member can request a roll call vote in open session, and that should all be in your minutes. All right, so I'm just gonna as we're closing out here, you know, I talk about this, again, this is not an issue with your board, I've had it as an issue with other boards, but how do you communicate effectively within the confines of the law? You know, we're always respectful. We always have to remember that your comments are recorded and they're remembered by many constituencies. The press can pick up on something, a member of the public can pick up on something, a member of the community can pick up on something, a member of the administration or any student can hear something you say and think and have it make a different meaning. How do you interact as a board on topics where you differ? How do you agree to disagree? Again, going back to that respectful communications, you're not going to always agree on things. That's why you were elected to bring your personal, you know, opinions, your personal experiences to the board. It is not reasonable to think that there won't be disagreement. There's going to be disagreement, but remembering to be respectful and always putting the business of the college first so that you can get the work done is so important. And building consensus and that's all part of the building trust for, you know, remembering all those things we've talked about, which is keeping the confidentiality of the discussions you have, even where you disagree with the outcome that the board reaches. You know, giving everyone an opportunity to share their perspective, to have, you know, robust conversations around important issues. The public needs to know and see that you all take the job seriously and that you are really thinking carefully about the decisions that you're making. And that is it, and I'm only 1 minute over.
Oh, wow.
Thank you all for your attention.
We actually have like 4 more minutes, because we started a few minutes.
Okay. All right, thank you.
Any questions?
Yeah, I was gonna say, are there any questions? Nicole especially.
It's a lot of information, I know. Woo, just moving through it, yeah.
A really good thing is we've got 2 resources that are available to us. Lucy all the time, and we've worked with Kate on and off for 10 years.
So, no, it's always a pleasure to be with you all, and you're in great hands with Lucy, of course. So thank you all for your attention. I know I moved really quickly, but hopefully it was helpful and you've got the
How
materials.
many other community colleges do you work with?
We work with 6 of the college. Well, we are outside general counsel for let's see, Jefferson, East Central, the Mineral area, and Moberly area. And then we do work with numerous other ones in a more limited capacity. So yeah. All right, thank you
And the
all.
reason I ask that is, it's a pretty small world, community colleges. The law, the issues, the number of boards, the ability to cooperate and work with other community colleges, it's just not a lot of us around there, so.
And State Fair, I'm sorry, I don't mean to forget State Fair. Yeah, I love Sedalia. They have a beautiful art museum if you've never been.
Oh, wow.
Yeah, the
State
Dom.
Fair,
Yeah, in Sedalia, the Dom, they have it's gorgeous. So if you're ever in Sedalia, go to their art
I
museum.
just got here. I got here for the last thing. Hi, Kate. How
Hi,
are you?
good to see you.
So good to see you. You look great. You look great.
All right, well, I will let you all get on to the next part of your meeting, but thank you for your attention. I'm glad everyone stayed awake. I think everyone stayed awake.
We did.
Thank you.
Thank you so much.